Right friends, welcome back to editorial discussion. Today is 11th January. The recent proposed amendments to the Aadhaar Act 2016, this appeared on 9th January in The Hindu. Critically examine recent proposed amendments to Aadhaar Act 2016. To understand this news item, one has to go to September 26 judgment of the Supreme Court in connection with Aadhaar. What was the judgment? Supreme Court struck down section 57. That means the telecom companies like Airtel as well as the banks, they are using Aadhaar for authentication of the person. In fact, that was struck down by the Supreme Court. Why the Supreme Court struck down? We are going to deliberate a short while from now. At the same time, section 33(2) was struck down. That means as per 33(2), identity and authentication data has to be disclosed in the national security clause, or you can say in the interest of national security, and joint secretary level officer can authenticate, or you can say can give approval, and that was also struck down. So, two important aspects please do not forget as per the Aadhaar judgment of September 26, 2018. Here, first important aspect is section 57 was struck down. Here, the private companies cannot use Aadhaar for authentication. That is the first aspect. Second aspect is this is in the interest of national security. Identity and authentication data has to be disclosed, which can be approved by the officer at the level of joint secretary. That was also struck down. And what was upheld? It upheld section 7, that means Aadhaar mandatory to access government benefits, subsidies, then social services, that is upheld. That means this is okay. And section 139 AA of Income Tax Act was also upheld. That means Aadhaar number has to be quoted in new PAN applications and filing the income tax returns. In a nutshell, as per the Aadhaar judgment of September 26, 2018, Aadhaar is mandatory to avail the subsidies and government benefits. Second one is Aadhaar is mandatory for the new PAN applications. Aadhaar is required for filing the income tax returns. So, these three are upheld. For these three, it is okay. But what is not okay is telecom companies, e-commerce companies, banks, they cannot insist on Aadhaar authentication. That was struck down, right? We learned in detail at that time. So, it is better if we recollect the information because now amendments are proposed, right? You can have a glance at it. Whatever I explained you is there in this slide with regard to September 26 judgment. And now let us come back to the present news discussion. Here, government proposed Aadhaar and Other Laws Amendment Bill 2018. What is this? In fact, the Supreme Court struck down the private companies cannot ask for Aadhaar authentication. Now, what the bill which was passed by Lok Sabha says is now private bodies can use Aadhaar, very important, private parties can use Aadhaar if the person comes forward voluntarily, right? If I comes forward voluntarily, then it is acceptable. That is as per the bill, right? So, this article talks about why this is wrong. Because of two things. When the person is giving voluntarily also, it is sacrificing right to privacy. Second important aspect is data protection bill. India does not have data protection, right? So, under these two circumstances, it may lead to encroaching into right to privacy. So, the author and predominant section of civil society feels let the government bring data protection bill first. If data protection bill is brought first, then right to privacy and what can be the exceptions, up to what extent people can encroach into right to privacy, all those things will be made clear. After that, government can bring this. That is the predominant opinion. Now government is bringing, if voluntarily, if I comes forward to use my Aadhaar for authentication, there is no objection. That is the intent of the bill. But one important aspect is it goes against the intent of the Supreme Court judgment. Though one of the paragraph might have mentioned that the government can go for voluntary use, one of the paragraph says voluntary use is possible, but you have to look at the intent or essence of the judgment. If you look at intent and essence of the judgment, why the Supreme Court struck down section 57? In fact, here section 57 was struck down by the Supreme Court. That means various notifications were issued by telecom operators, e-commerce firms and banks to use Aadhaar, and this was struck down by the Supreme Court. Why the Supreme Court struck it down? If you understand that, then it will be very clear the essence of the Supreme Court judgment. The essence is important. The intent is important. Right. Why the Supreme Court struck down section 57? The court felt that the impact would be commercial exploitation of individual biometric. What is biometric information? Biometric is this, right? And demographic, that means information pertaining to me. So biometric, then demographic, that information may be exploited commercially by the private entities. So therefore, the intent is very clear. Here, the body corporate. What is body corporate? Body corporate means companies, don't confuse. So body corporate and individuals who seek authentication may impinge into right to privacy. Right to privacy is now the fundamental right after Puttaswamy judgment. So right to privacy is the fundamental right, and if Aadhaar is given for authentication, then they may commercially exploit, right? And advertisements may come based on your preferences. So that is commercial exploitation. So commercial exploitation is not acceptable in the case of Aadhaar. At the same time, it impinges right to privacy, which is the fundamental right. So therefore, the Supreme Court struck down this because it impinges into the right to privacy of individuals. At the same time, commercial exploitation by the companies, telecom companies, banks is possible. So therefore, it declared unconstitutional. Right. But how the center is now introducing amendments? Center is not looking at intent of the judgment. Center is not looking at essence of the judgment. It is looking at only one paragraph. One paragraph says there is no problem if a person voluntarily opts for it. There is one paragraph, no doubt about it. But what is the essence of the Supreme Court judgment? Supreme Court judgment is it violates right to privacy. Right? Right to privacy is the fundamental right. Right. So under these circumstances, the important aspect is the government first bring data protection bill. That is the predominant opinion. Then one more important aspect. Through the same bill, government proposed certain amendments to the Telegraph Act and the Prevention of Money Laundering Act. Here, what the proposal is, here the authentication is possible only 4 ways. One is authentication under Aadhaar Act. Offline verification under Aadhaar Act, that is to QR code. That is known as offline verification, and use of passport, use of any other officially valid document for verification which the government may notify. These 4 conditions are given for authentication. Let us assume a situation. Suppose government has not notified any other document. Then what happens? Only Aadhaar is left over as well as passport is left over. But how much percentage of people in our country have passport? Right? Very few percentage. So therefore, Aadhaar will become de facto for authentication. So that is the reason why the intent of the government is not clear as per the Aadhaar. Right, friends? So therefore, the predominant view is, though voluntarily before introducing clause for authentication, what is important is right to privacy judgment is to be respected. That is the first aspect. And the second aspect is right to privacy is now fundamental right. So to in fact look at it as fundamental right, the most important aspect is they should bring first of all data protection bill. Then what are the problems if the companies use Aadhaar? I have already explained you, commercial exploitation is possible, fraud is possible. There were number of reports with the seeding of Aadhaar. There were several reports of fraud emanated, and it impinges the right to privacy. So the need of the hour is data protection bill. Not only this, look at section 33(2). Supreme Court in fact struck down section 33(2). What is this 33(2)? I already explained you. 33(2) means here the clause allowed the officer of the rank of Joint Secretary to Government of India to direct disclosure of Aadhaar information in the interest of national security. In fact, Supreme Court struck it down and said that should be with higher ranking officer. And in order to avoid misuse, it should have a separate scrutiny, right? Therefore, a judicial officer should also be associated with the process. But what the government has done? Government simply replaced Joint Secretary with the Secretary. Right, friends? These are the points emanated from this the Hindu article of yesterday. Right? So let us leave this discussion here. Section 57, section 33(2). Right? These are the sections which were struck down by the Supreme Court, and now government is trying to incorporate with some modifications. Right? One is voluntary and the second one is a joint secretary is replaced by secretary without any judicial officer for scrutiny. So these are the points emanated out of this article. Have a nice day, nice weekend. Thank you.